Hey guys, can you hear me? Check in. Let me get to my comments here. Hi, Tara. Nice and early, I see. Let me know if you can hear. Let me know. I am not getting anything here. Can you guys hear me? Can you hear me? I don't know if you can hear me. Hi, Salvatore, Emma, NYU. We're going slow today, huh? Punta Gorda, Florida. Hi, George. Nice to see you. Did we meet before? I don't think we did. I always try to think of these names. Smiley face. So what have you guys been up to? Are you guys all in the middle of a claim, or are you beneficiaries, or where are you at? ¿Dónde está? In the process. Oh, I was just getting together some tax returns from an SSI client who the SSA wants to see the tax returns because he was self-employed and there was very little income. I mean, way under SGA, almost barely noticeable. But, you know, when you're self-employed and you file your own taxes, I think they're looking at, like for his 0 years, like what was your revenue? What was your expenses that brought you down below SGA if your revenue would have been above SGA? All that kind of business. So helping get those together, and then I will be shooting them up the pike. George Graham, is that the same name? Or do you use a different name? I don't know. Yeah, so sometimes if you're on SSI or you're applying for SSI and you're self-employed, because self-employed people can finagle with their numbers, write things off, all that kind of business. Sometimes there's a little bit more scrutiny than if you were a W-2 employee for somebody. So this would be true potentially of, why does that not? I'm sorry, George. I'm just having a brain fart, I guess. My apologies. Justin Yu, I remember that. I don't know why, George. Okay. Oh, Justin Yu, you're still waiting for a hearing date. You sent SSA paperwork back weeks ago. Justin, was that paperwork for appealing for a hearing, or was it some other kind of paperwork? Salvatore, Emma, I certainly hope there's no stimulus coming out soon. That's the last thing we need. We got a bunch of deficit, but I don't want to talk politics. All right, let's just talk SSA business, please. It's driving me crazy. Going back to it, if you're SSI applicant, they're going to want to, and you're self-employed, they are definitely going to want to, even though they have it recorded on your earnings statement, they want to see the meat of how I believe, of how you got to say 0, despite being self-employed. And it's not difficult to do. You just got to show them your Schedule C so they can see the 1040 and the attachment, the Schedule C, so they can see, okay, he brought in the 1099, said, if it was 1099, sometimes our revenues are not 1099, they're just straight cash. We, calculate them, and that's our gross, and then we subtract our business expenses. They're going to want to see that, just to, I guess, make sure. Okay, so we're just talking about some paperwork that somebody got in. I'm just going to pop you up here, Justin. Justin, you sent in paperwork for how I want my hearing. I choose by phone. Okay, so when they start getting, it doesn't always happen that as soon as they get that, you choose by phone, huh? I would have chose by video, unless you're like a rock star looking. I don't know, for some reason I prefer video, but phone is fine. Once they send you the options of, will you do video? Do you want phone? Do you require in person? It's not always right after you send it back that they're like, okay, let's get that scheduled. I don't know what the holdup can be. Technically, in my opinion, they should have the entire file exhibited for a hearing before they schedule the hearing. I've had disputes with some OHOs when their scheduling department, which is separate from the judge, it's not really the judge's fault, has gone ahead and scheduled something, and they have to give you at least 75 days, and they schedule it, but there is no exhibited file. The file is the same mess it was down below. Nothing is exhibited that will be in the hearing. So technically there's no evidence going to hearing yet. And I find that to be a due process violation in the SS world, because a claimant needs to know what evidence the judge is permitting to be included in his hearing before he knows what else he needs to do to strategize. Not to mention, from a lawyer point of view, if I'm going to do my brief, which I always do briefs on all of my ALJ hearings, even though they're not required for a few different reasons, I want to see, when I do a brief, I want to cite to which exhibit I found certain evidence to be in. I might not be doing pinpoint citations, but I want to at least say it's at 3F, or 4F or wherever. And then I always have in my brief, if you want pinpoint citations, which have been left out in the interest of brevity, I could certainly put those in. They take up a little more room, but they also take up a lot more time because you got to record it every time you find a good statement, blah, blah, blah. So I kind of keep it to the exhibit and not to the pinpoint page sometimes. But if they don't have it exhibited, I can't even do that. I can just say somewhere in the case file, which may not be in the exhibits, because maybe Your Honor, you're not going to let that piece in. I mean, how do you even fight a fight if you don't know what the evidence is that's going to be allowed? So I have a problem with them scheduling it before they do that. I think they need to do that first. That's a whole different probably group of people at OHO that exhibit the file. Good, bad, or ugly. They don't always do it very well, but the point is, at least it's done, and there's references that can be used. So, but they don't always do that, Justin. So they might go ahead and schedule you. I never see them scheduling like 8 months out. I'd see them scheduling between the 2.5 months and say 4, maybe 5 months out tops. So I think they kind of rein it in and don't just keep piling it on endlessly. So yours would be in a queue at least, so that when the next ones come up to be within that 2.5 to 4 or 5 month range, maybe that's how they do it. Because I know they don't schedule them out a 1.5 years later, which they probably could, given how the docket is. Okay. Oh, you have a stutter. Okay, wait, hold on. So Justin, you have a stutter, difficult getting my answers out to a judge or anybody. I still think a video would be good. The judge can see your face. It might be frustrating when you're stuttering, and he can see the anxiety it builds up in you. I mean, that anxiety, if you have it, would be noted in your medical records, because presumably, you've discussed it with your providers, hopefully. But not the phone is the worst thing. They can hear it, and that's you might be considering that one of your impairments. Maybe it would eliminate phone jobs where you need to, be on the phone or speaking with the public on demand, or if it gets worse with anxiety and stress, it would certainly help reduce the jobs out there to eliminate all jobs of a certain stress level. Something to be said for that. Hi, George. Yeah, put it out there. I don't recognize your face, George. So I've been on SSDI for 30 years and my wife since 2022. We had to pay federal tax on her lump sum, over $5,000 in taxes, and this in this year, 2024, over 6K in death mutual funds, any chance for a refund? I'm not a tax expert, so I have no way of knowing. You'd have to go to a different a tax attorney for that information. Plus, it would have to be someone who reviews your information. So you might want to go to your own tax preparer or accountant to learn that. Okay, George? Yeah, that's all I can say, unfortunately, about that. George, you're not gibberish. It's all good, but I can't answer the question about whether you can get a refund on taxes. Unfortunately, not my pay lane, my friend. So, very quiet today, guys. What's going on? Very, very quiet. Maybe we won't be going to the 2, pushing to 3 hours. Although, like I said, I do want to curb it at 2 hours so I can plan the rest of my work day for productivity. So what else, people? Anything exciting going on? I'm really not seeing a lot of questions. Come on, there's a couple dozen of you in here. Don't be shy. Don't be shy. What else went on? We had a couple. The announcement that came in last night from the SSA that they have streamlined what was going to be another 10 months out for the WEP and GPO people, pensioners who are got relief from that Fairness Act law change that came out at the end of last year, I think it was, or the very beginning of January. That's going to be paid out like in a month, the back benefits for the WEP and GPO affected people. And apparently there's like over 3 million of them for their back benefits resulting from an increase in their benefit from January of 2024 on. And then, of course, their prospectives are going to be increased. And that is happening now instead of in 12 months, like was originally forecast. So that's good. Good for all those people that are affected. I know most of you aren't, but for those that are. Hi, Rito. How are you? I had my hearing in January. At the end, the vocational expert said he could do these 3 jobs I could do. Well, he was saying a hypothetical person can do, Rito, because remember, he's not talking about you. He's talking about the hypothetical person that the judge put in front of him, which may or may not be you. So the VE said that you could do those 3, that the hypothetical person could do those 3 jobs. But on cross-examination, the VE said, no, I would not be employable, and I was still denied. Okay, so let's go back to what it is. The VE is not talking about the claimant. So when you're in front of a vocational expert, when you're at your hearing with the judge, and the judge asks the vocational expert questions, if you listen carefully, he asks about a hypothetical individual who is the same age, education, and experience as you. Not you. That's just someone with the same age, education, and experience as you. Not your medical, hasn't been put in there, and your functional limitations. Then the judge adds limitations. He'll give an RFC of whether the hypothetical person limited to light work, Mr. Vocational Expert. And perhaps he'll say, but has to sit 4 out of the 8 hours instead of 2 out of the 8 hours, Mr. Vocational Expert. Would there be any jobs that person can do? That's not necessarily you, because clearly not you, because there would be jobs that person could do. And you are asserting that you have other functional limitations besides the ones just presented, because there's plenty of jobs a person who can do quasi light work can do. Maybe you have finger impairments that mean you can't use them frequently, and the jobs that the vocational expert listed could be done by someone with recognized frequent limitations that bring you from constant to frequent with fingering or handling. I'm just throwing that out there. But so when you listen to the audio, and I don't know if you can get a copy of the audio, your attorney can though, or your non-attorney rep, if he's, practices enough to be registered to be able to obtain that information. The judge put out hypotheticals to the VE. They are not you until he assigns one of those hypotheticals to you later when he's making the decision. He has to find that, generally speaking, most of the time, he's going to match you to one of those hypotheticals. And then matching you to the hypothetical he gave a VE, what was a VE's response? Can that hypothetical person that you now equal for purposes of a hearing, can that hypothetical person do a job? If so, you could do that job. And that's what happened. And usually the way it works out, and this is how denials happen when there's a VE and an ALJ. The ALJ did not provide an RFC with the level of limitation that you believe or your attorney believes you have, and that is supported by, hopefully, by the medical record. So if the judge left out a pertinent limitation that stems from a diagnosed impairment and he didn't include it in the RFC, that can be an appealable issue. It's unfortunate that you now have to go and appeal and do this, but that's kind of how it works. So when I see a hypothetical and there are jobs available, and usually there's more than one hypothetical, but if there isn't, I myself would be cross-examining on a second hypothetical, usually the first one, and then I add in all the things that I know exist and that I could point to in the record if I have to, that the person has. Like, let's say the judge doesn't include any hand impairments or hand limitations, which means you can use your hands constantly. If that wasn't included in the hypothetical, and I know I can point to evidence of that, I may ask that. There's a few ways to ask it, but the vocational expert, hey, Mr. Vocational Expert, for those 3 jobs you mentioned for the hypothetical that the judge gave you, hypothetical number 1, and I've taken notes while they were, I'm always scratching notes about what the hypotheticals, so I know what they were and which ones they were. I would then be saying, do those, what level of fingering and handling do each of those 3 jobs you mentioned require? And then if he says frequent, or constant, and then I might throw out there, so if a person is limited to 2 or 3 hours of fingering a day, but can't do more than that due to medical impairments, would those jobs be unavailable to that person? In which case, he has no choice but to say, yes, they'd be unavailable to that person. That does not mean I win the case. It just means I put something out there for consideration, because the judge can still find that my guy is not limited to only occasional finger use, which is like 2.5 to 3 hours out of an 8-hour workday, and that he could do something more. I do see them very often acknowledging a finger impairment, let's say through general arthritis or something, but saying the person is limited to frequent. Oh yeah, he's limited. He's limited to frequent. Frequent is a lot. That's like 6 out of 8 hours or something like that. 5.5 to 6 hours. So I think it's kind of a ploy. It's kind of a practice that's very pervasive. When they need to deny, but they have to acknowledge the finger impairment, they may say it's there. He can't do constant, but he can do frequent, because so many of even those jobs where you need hands, you don't need them constantly. You need them frequently, and that's how they shoot those people down. So we just try to argue that you have to put out the argument, to rebut it, and then sometimes it can be used later on appeal, particularly if the medical evidence shows extreme arthritis of the fingers, constant complaints about the fingers. And that's when a person's not even working. So they're probably not even using their hands that much in their day-to-day at-home kind of genteel activities. Something to be said for it. It could work on an appeal, for instance. One way or another, whether it's expressly or not, it's now kind of part of the record. All right. So we got some questions coming in. Good for you guys. But Rito, just to drive that point home, the VE was not talking about you. He was talking about a specific hypothetical that the judge gave him. And it would have been your lawyer's job to create additional hypotheticals to get that VE down to no jobs. Hypotheticals that he can add because he knows the medical record. So if he or she didn't do that, or you're not attorney rep or whoever you had, that was a failure on their part to do that, in my opinion. You don't just leave it alone. Okay. Okay, where are we at? Oh, hi, Kevin. Kevin V, nice to see you too. M. Thompson, I'm not even going to put it up because I don't think it's appropriate to talk about politics on here because it gets people very, very crazed. And I've had enough crazed people with politics and every day, it seems. So I'm going to pass on that. But I will say I have no reason to think that's true for disabled people. Fraudsters, foreign and domestic, of course, that's the hope, but not for actual disabled people. And I've seen no indication to the contrary at all. Okay, John Calamas, nice to see you. Thanks for sharing. Can you discuss filing a brief before a hearing? What is typically in the brief? Is it helpful to file a brief, etc.? Thank you, Stephanie, for all you do. Oh, you're welcome. And thank you for being here. Briefs, not required. And I would say practitioners are split on whether they do them or not. Obviously, they're very time consuming and we don't get paid by the hour. So it's unpaid work in theory. I find them to be very helpful and I do it in every case. I do it for a multitude of reasons I alluded to before. I find that, and by the way, I've tweaked the style of my briefs over the last 20 years incredibly. I have more of a process now versus the more crazy way of just jumping in. It's actually started back when I take a case. The very beginning of it is started, and then it starts getting filled in. And then in time, my theory of the case comes to be, and the nuts and bolts are in there. And what I do is because they only want 1 or 2 pages, they don't, as far as I understand it, ALJs do not want to read a 20-page brief. However, they might appreciate a theory of the case or statement of the case, sometimes we call it, bringing home, driving home any issues that happen to be relevant. Like if there is a, I can't even think of one off the top of my head. Maybe you're considering amending onset. I would throw that in there, like, we've discussed the potentiality of, but those nuts and bolts are going to be in 1 or 2 pages. But then what I do is I have an attachment, and it includes every provider and their treatment dates. I do this so, again, part of it is for us to make sure we got everything in there, but it also says where that doctor's evidence will be found. And within that, so let's say I have like 10 dates, Dr. Jones and the 10 dates. In the dates where there's something substantive in that medical record that I want the judge to draw towards, I will put that in parentheses and quotes and put it right in there under that date. So it goes, and then I happen to divide them by everyone who was last seen in 2024, even if they were seen, or 2025 now, even if they started seeing them and they've been seeing them all these years, I put that in the 2020. I do it kind of chronology. It's like in a bulk chronology. So like Dr. Jones, who you're still treating in 2025, all of his stuff is going to go under the first category of 2024 evidence, because I want him to be able to see the recent stuff, and then he can see the ones you haven't seen since 2023 and back, and the ones you haven't seen since 2022 and back. So that's one thing. That's my provider section in the attachment. So I call it an attachment because sometimes these things are like 8 pages, but that's not part of my brief, Judge. My brief is only 2 pages because, I want to keep him focused. I don't want him to be turned off by the number of pages. That part could be technically ignored. It's just very helpful to have because there's also a section in the attachment for diagnostic tests. So there's going to be from most recent going back, all the MRIs, X-rays, and I always say includes, but is not limited to, because sometimes if something is very innocuous, I'm not going to include it. I'm not taking up space. But definitely anything with any kind of notable findings on a diagnostic, very, very important. And then I have a section on therapies, surgeries, and what's the other thing? Hospitalizations? I don't know. I forget. Because it's all in like a template. But that would be physical therapy courses. Now, keep in mind that the physical therapy office is up in the medical provider section too. But I want them to see all these therapies in one quick section, because some judges really rely on seeing that the person was really it gives a person perhaps a little bit more credibility as to how severe the pain is if they are attending physical therapy. Because that's a lot of time out of your day. You got to get up, you got to get showered, you got to go. And if you're not feeling well to begin with, you know what I mean? That can be indicative of how serious you take your own impairment. Injections, epidural injections for musculoskeletal, those would go in there in that section. Surgeries, laminectomy, fusions, whatever. It could be other kinds of surgeries as well. So conservative therapies, less conservative therapies such as surgeries, they go in that section. Now, going back to the main part of the brief, again, that's going to have like a paragraph about the theory of the case, and that's where I include grid. If it's a grid case, and I'm trying to argue that one should prevail on the grid. If it's a younger person case, but I want to drive home but this person is, relegated to less than sedentary. They can't even do a sit-down job full-time, judge, because of blah, 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 blah. In that section, I do have one bulleted section in the actual main part of the brief as opposed to in the attachments, and that is all of the major impairments that I think are severe. And yeah, usually not the non-severe ones, but I put everything else in. So that's also right up front and center. Here are the impairments, and I usually try to throw in an exhibit or two where you're going to find that diagnosis. That's my idea on briefs. Not everybody does them. I have some judges who thank me for the brief, and then some judges you could tell never read it. So I know some practitioners don't want to do them because it is so much time, and sometimes a judge doesn't really care. I'm just not one of them because I go full hill all the time. Not to mention, you don't know if that case is going to get shuffled off to a different judge. That happens. It can be over, the docket is too heavy and that judge they're going to take it and put it to somebody else you don't even know. It could be the judge passes away, the judge gets ill and takes a leave. There's a multitude of reasons you can get a different judge. So, and then of course, like I said, the other major reason is it is how we make sure not a single stone is left unturned in this client's case. All medical evidence is updated up to almost the day of the hearing to the extent that's possible. But we do a lot of communicating with our clients, so to keep that really up to date. But it used to frustrate me. I used to hate doing briefs, but I felt the need. Now it's not so bad because we have this very streamlined process over the last several years, and it's just working out much better. We started, again, like I said, if I get someone on initial or before initial, as soon as I'm putting together the application, certain pieces are going into that brief already. They're going to be tweaked along the way, perfected, threading that needle. But I find it to be far less stressful for me. And it means I can also get help from my staff, because it used to be I was doing the briefs all by myself because I'm type A and I didn't trust anybody to not miss something. So this works out much better. Hi, BL. Okay, have fun at your appointment. Good luck with it. Thank you for liking. I appreciate it. Okay, let's move on. We've got a blank name here. What happens if you start working at a job while you applied to Social Security and they said they're not going to give me my answer till September? Okay, first, what you probably read was their estimate that it takes XYZ days to get through. And that's kind of a warning that it could be slow or not. This has been going on for a few years. It is unfortunate. I hope that things will be running better soon, with better proper staffing and all that business. If you're going to work, just know this: if you start to go back to work, guys, if you keep your work under SGA, you're safe from the amount you are earning. They're not gonna cancel your claim because you are working if it's under SGA. There are other possible reasons to make it even lower than that and under TWP, but we're talking about keeping a claim going, right? And if you do go over, let's say it's called, they want people to try to go back to work full time, because what if you get a job that you can do? It just works great. Like, you have disabilities, but you got this really cool job. There's not a lot of them out there, but you secured it. Maybe you had a connection. Maybe it's through a family friend, and you're working over SGA. You're doing full-time hours because it's very accommodating to you, and you are earning way over SGA. If that lasts more than 6 months, that's sustained and it's successful. So that would interrupt your claim. However, if that happens and if someone is under 6 months, we appeal it because we want to see if it lasts more than 6 months and becomes sustained, in which case, shut it down. No harm, no foul. You filed, you withdraw your application, you're good. And you can later file again. If you lose that job and you know, or have worsening problems, you can refile. If that's, you know, the SGA work is under 6 months, and then you're trying, you take the full-time job because you got a mortgage to pay, put food on the table for the kids. You can, if you stop in less than 6 months, and if you stop because of your disabilities, like that was really way too hard. I pushed it as long as I could, but I was in such pain I couldn't even function when I got home. That could be a failed work attempt. I know we have videos on that. And then that doesn't have to interrupt your case. You might have to appeal it if you get denied while you're still working, because the SSA will have no choice but to deny you because of step 1 is the person working SGA. But that's why we appeal. Now, if you go to an ALJ and you're working, that's going to be a whole nother story. So you have to really plan things a little better. But under 6 months, failed work attempt, if a judge finds you disabled, that piece of work for 4 months or whatever that failed, but you're making a ton of money, is not going to stop your case or stop you from winning. All right. And that's assuming, again, that you had to stop because of your disabilities. Okay. So I get what you're saying. And you're just, by the way, you're just an orange circle with a line through it because you don't have a name on here. So I can't say hi to your name, but I understand it. He's saying that he can't afford to not work all the way through to September. Consider doing under SGA, and then you could do it forever. If you do any kind of work, make sure it's not so contrary to your alleged disabilities, pain levels, etc. And you can always do the trying. Work for a few months full time. If it's not working for you because of the pain and the limitation, then stop. And then stop for at least a month. At least a month. That's the rule. In terms of that being a failed work attempt that was under 6 months, you have to then stop for a month to cut it off. You can't just take a week off, okay? Because people do that for vacation when they're not disabled. I hope that helps. I get it, though. That's very common, so don't feel like you're alone. And people successfully work under SGA or do try to do the work attempt and then it fails. So you can do it. Viv. Hi, Viv. You know, today I'm not even going to ask somebody, hey, have we met? I don't think we've met because I already screwed up one. And usually I'm good. So I'm definitely not on top of my name game today. Okay. Oh, Angela. Okay. The one without the name. Gotcha. Yeah, if you can get a lawyer, Angela, I recommend it. But of course, I'm biased like that. As everybody knows. I think everybody should have lawyer or non-attorney rep. Just someone good, someone dedicated. Okay, sounds good. George, well, we can always see if we have openings in that category. Every category is different, but yes, that's totally fine to inquire. Okay, Kevin has a good question here, guys. I was reading that Social Security not only goes by your disability, but your education and age too. Is that true? Well, it is, because that is your vocational profile. Age, education, and experience. So absolutely, it's relevant. That your age is going to somewhat decide if the grids can be looked at as potentially applicable. Education, the same thing. Now, keep in mind, education is not such a huge deal if it is not recent. You know, if anyone got through most of high school, we're all considered reasonably educated, and that is the level, short of which doesn't always matter too much. And like if you quit in 10th grade, it might not be a huge deal to your case in terms of helping you. You won't have all it means is your education will not put you directly into skilled work. So you got the unskilled to deal with. The more important part of it is your experience. And that's where that past relevant work of the last 5 years, guys, comes into play. Because that work, if it has semi-skilled things in there or skilled, it's going to determine kind of like the standard you're held to. That 5 year, I mean, it's really an important critical component of the whole thing. The education, usually most people didn't go get a phlebotomy educational training in the last, couple of years. Usually it's something before then. And then that is it, depending on what it is. If you haven't used it, that education you got 7 years ago probably would be arguably not something that could now put you directly into skilled work. You'd probably have to have a refresher, whatever it is. So the older the special training is, or the recent, the bachelor's of science, and obviously some of those don't put you into skilled work either. I mean, underwater basket weaving, do they even have careers like that? I don't know. Anyway, I hope that helped explain that, Kevin. So it is very important. Okay. I don't see a question there, Margot. I love that name, Margot. I think it's so cool. Earth sign. 41 years old, taking 3 medications for my anxiety, depression. Okay. I had 1 hospitalization, was in inpatient behavioral health facility. I just received a benefit summary of my claim. Benefit summary, meaning, I don't know what that means. I wouldn't know, Earth. I'd have to look at it. Does that mean I'm approved? Sounds like you're saying you applied. I don't know how long you applied. Has it gone through medical? Did you do a function report? 41 is a very, very difficult age. Your medical records, particularly if you're purely mental health related, the medical records, you can ask anyone who shares information like this, my colleagues. Mental health has to be really severe to say you can't do even a basic, very simple job full time. No skills, 3rd grade work, it has to be really extreme. So they look at your day-to-day functioning, like, do you go to the store? How do you buy your food? If you're leaving your house and getting things done, it's gonna be hard to win purely on mental health. But people do, because sometimes there is a cycling, and there, it could be, I mean, I had one fellow who, he wasn't in the hospital, but he was agoraphobic out of this world. And the biggest, I still don't know how we won when we won, because, I mean, you shoot for the moon, right? But he wasn't even going to the doctor because he was afraid to leave the house. And he wouldn't want to talk to me on the phone because he thought it was being spied upon and things were coming through the lines at him. So it was that bad. But fortunately, there was a prior psychiatrist that he did see who really put in his 2 cents in writing. It was kind of a miracle case, actually, because the way they tend to be with these ones. But so benefit summary, if it says you won your claim and you're getting it this much, then you won. But I can't really tell from your information, Earth sign, unfortunately. Benefit summary is if you're collecting, usually, unless what you're referring to is your estimate of what your benefit would be should you prevail, because you can get that online. Well, you can get it online until you apply. Then they wipe it off. Oh, Margot was a nurse and she's going to miss it. I get it. By the way, Margot, they look to see if you can do other jobs, not just nursing. So always remember that, guys. It's not just your old job. It's all the other jobs too. The minimum wage jobs, the unskilled jobs, all that. George Graham, I appreciate no politics, just peace, love, and rock and roll. Sounds good to me. Oh, M. Thompson, don't worry. I didn't say that to accuse. Your question was fine. I just can't do it here. I just can't do it here. You know, I do get it though. I do get it. Angela's only 45. Yeah, you gotta. It's harder when you're under 50, guys. You know it. You know it. You've heard it all over the place. Not undoable. We had one last weekend, the week before, 2 of them, but it's an uphill battle. Sometimes a very long one. Definitely worth doing though, because if you're disabled, you're disabled, and you know it. So. Earth Sign's talking about some of his parameters here. Medications for depression, anxiety, and schizophrenia. So you added in the schizophrenia. The details of your mental health records and your mental health provider's willingness to share them when you have asked them to, signed a full-blown release to get the nuts and bolts, it is going to be I think a big hinging factor. Some mental health providers consider themselves godlike, and they feel they can withhold these things from your case even if you ask for them. They confuse the right to withhold psychotherapy notes with the right to withhold everything else, which is false under HIPAA. Yeah, I believe I've inhaled HIPAA since I started doing this kind of work. So I have seen mental health providers successfully, contrary to probably what they wanted, but their ignorance led it to this conclusion. They cause sometimes people to lose their cases. Very disabled, mentally disabled people to lose their cases, because you can't win a case if you don't have sufficient mental health records. So don't get me started on how frustrated I get with some of the more ignorant mental health providers who say, oh, no, we can't provide the records. I'll just tell you that we're treating them for depression, anxiety. Oh, really? So is half the population that's working treated for depression, anxiety. So that doesn't really fly. I do think people should start filing OCR complaints with providers who do that. Personal opinion. I'm not litigious, but I think, if they're preventing you from pursuing your legal rights just because they don't want to give up the records, and then you got to wonder why. Why? When it's a blanket reason, why? When they do it for all their clients, why? I think it's because they don't have faith that they did a good job with the records. Sometimes I think they don't take notes at all. You ever see the movies where the shrink is snoozing while the person's, and then he's like, oh, yeah. It makes you wonder. It's one thing if they're like, no, we can't provide these, because it could be the person confessed to horrible, you don't know, and there could be they're fearful. Now, granted, the SSA is not supposed to be doing this, but they're fearful that the person could now get in trouble or whatever. It's one thing to specifically have a reason for a particular client not to release, but to have a blanket rule means it's something a little stinky about that. Hi, Trish. Good to see you. Let's see. Oh, George Graham, thank you. I appreciate. Lulu, nice to see you. If I get denied, can my attorney file an appeal without asking first? I will not. Oh, I think we talked about this last week, right, Lulu? I will not want to appeal because I don't want to continue with this case. It is making my problem worse. Thank you. Yeah, I know we talked about this last week. So, and that is up there. I haven't pulled out the particular question response. We're trying to start to do that, so that you could, one could see it without having to listen to the whole 2 hours and find it. But that's it's kind of a time-consuming. I'm low on tech here, so, but hopefully it'll be gotten to. But in any event, it's can they appeal without asking first? When you signed them up, it was probably with the understanding that you were going to file it. You're going to fight the battle all the way through ALJ hearing. Now, if you this is my opinion. I suggest you ask some others. If you say, I don't want to appeal, I want out, I think the attorney has an obligation to honor that and to assist you in getting out. It could, I mean, there are different thought patterns. Some people say, well, just don't appeal it and it's going to get denied. Okay. Or you can actually overtly, and I think I talked to you about this, Lulu, there is a form. I don't know if it's the HA85. I'm speaking off the top of my head, where you can withdraw your application for disability benefits. You can do it yourself. Now, I have heard, I know one person said they did it, and the SSA staffer said, oh, no, not unless your attorney does it. That seems inappropriate to me also. But, you know, you've got some staffers that just don't know things. Maybe they should have reached out to the attorney and said, you know, your client has reached out and wants to withdraw the claim. Have you guys discussed this? Blah, blah, blah. And ultimately, I think it should be totally the client's decision. That said, sometimes we have a situation where a client disappears. You know, you can't even reach them, and then they get denied, and you're like, well, I got to protect his appeal rights, because if you don't appeal, you might lose some rights on that particular claim, which could, in theory, depending on when your DLI is and everything else, it could not only lose you back benefits if you were to win later, it might lose you the opportunity to file at all. So I think when it's a situation where you don't know what the client wants because they disappeared, as an attorney, you kind of have an obligation to protect their appeal rights. I would probably do that, and then I would probably have to withdraw, because I can't be providing services when my client is not responding to me. But on the same token, if you express that you want to withdraw your application and not appeal, I think you should have the right to do that. Withdrawing an application can kind of zero everything out at times. It's like you never applied, which can be okay, because that means you could do it again later if you wanted. But so, yeah, I got a little problem with an attorney making the decision for you as an adult. You know, if you're incompetent to that level, if that's what they're saying, well, then you would have a guardian or something, wouldn't you? So I you know, this is just my thoughts off the top of my head. I would suggest you know, I would speak to the attorney. And if you feel like you're sending in, you know, you're speaking stuff and they're not listening, maybe put it in writing and send it certified return receipt or FedEx, UPS, and then you have proof that they received your decision. So if things progress down the line and you have to say, listen, I told them, you know, they don't represent. Plus, you would have proof to the SSA that if you terminated that person. And that's one of those 1696 SUP forms where you can terminate your relationship with your attorney or non-attorney rep. And if you're going to have an SSA person that says, until you have an attorney, we listen to the attorney only, which is really weird to me. That way you get rid of the attorney, and then they have to listen to you. If they're going to pull that kind of, I think it's kind of abusive, but okay. Randy. I hope that helped, Lulu. Randy, I know it's not 100%, but what percentage do 55 and older get approved? They haven't told us that, Randy. We know it's higher than the rest of the population. It certainly is. That's why a lot of attorneys only want over 55 clients. You know, it makes for a more sustainable business practice, but I feel we all have I shouldn't say we all, I don't want to speak for other people. I feel compelled that I have a duty to represent all ages. But I do love my 55 plus crowd. And back pay, by the way, it's a completely different question, Randy, because it's going to depend on if they were waiting a long time and back pay accumulated, or if they didn't, if they just became disabled. So those are very, very different questions. Let's see. Yeah, you can always reach out, Randy, if you want me to look at your case. It's totally fine. Let's see. Hi, Christina. Good to see you. Viv. Okay. Application, February of 2024, age 62. Diagnosed at 37 years old with psoriatic arthritis. Oh, I know that can be troublesome there. And other conditions. Hand, finger, and neck fusions cause severe impairments. They are severe impairments. I think you mean they cause severe limitations, right? I mean, fusions, you can't move that. That's fused together, right? Right, Viv? See several doctors regularly, continued below. All right, so I'm just going to pop down to Viv. Records uploaded to SSA by attorney. Okay, you have an attorney. That's good. U.S. Senator, inquiry done. For what purpose, I ask you? Too early by me. Oh, are you saying you were impatient and you asked for a congressional inquiry? I have some videos on that of when I think they're appropriate and when I think they're not. You had an attorney, so probably that should have been his decision because that's a strategic one. It's not like the one we were talking about with Lulu about, listen, I don't want to even have a claim anymore. Let me cancel. Medical, mental exam requested. Medical done. Mental is tomorrow. Okay, fingers crossed. I'm glad those videos are very helpful. Vivian's just pointing out, guys, that we do have some videos on consultative, and it might even be in the playlist, consultative examinations. Just kind of gives you some heads up about things to expect and you know, the very things you want to be honest about and not be shy, even though you might normally be shy about these things and not sharing them so much because we're all very personal and we like to keep our wounds to ourselves. The CE exam, you know, might be a place where that's not the best idea. So Vivian goes on to ask, what more could they need or question? All this makes me worried. Will soon be 64 and hope I am not on my way to denial city. I'm sure your attorney has everything in order, Viv. I would be surprised if they don't. The consultative examinations often, not necessarily all the time, but generally speaking, they're supposed to be when you could very well be disabled, but they have to confirm a few limitations that are not very clear from your medical records. Maybe you weren't following up, you know, recently with a mental health provider. And so they need to prove if, you know, they need to confirm that you have that mental health issue that might then prevent you from transferring those skilled jobs you had before to a nice, easy, sedentary skilled job now that they might think that your exertional brings you down to. So that's all those rules in the grids. So it's not bad if you're getting a CE exam, you know, and you are in the age group where in the grids are top of the line for that. So, you know, fingers crossed for you and just keep your chin up. Your attorney has every incentive, as I always say, every incentive in the world to prevail for you. And you do have the best grid rules available to you. So that's a plus. You know, if your mental health records were, you know, as I mentioned before, weak recording or weak sharing by your provider, you can thank them for that. They just forced you to go to a consultative examination. But for someone younger, they would have to prove much more than you have to prove with those mental health. You really only have to prove that you can't transfer skill jobs, potentially. Do your old job and or transfer those skills to a different job that you could physically do. Whereas a younger person under 50 has to prove that that mental, you know, contributes to eliminating all jobs, you know, including the sedentaries and the lights. A much higher burden. Jeffrey Taylor, yeah, you're late to the party, pal, but good to see you. Ronnie B asks, the new Social Security raises, does it go to SSDI? I think Ronnie's alluding to the COLAs, cost of living adjustments. They happen every single year. On a rare occasion, if we have stagflation with a poor economy, there will be no COLA raises to our benefit amount. That's rare. That's a pretty crappy economy. You know, usually you want it to be in that 2-3%, you know, 2% range, I guess, for a healthy economy, not an overinflated economy, but not a stagnation either. Stagflation, excuse me. And yes, it applies to all Social Security benefit amounts, fortunately. Margot says she's a 64-year-old registered nurse. You know, my mom and my sister registered nurses, Margot. Out on FMLA for late onset MS. Sorry to hear that, Margot. Is it better to retire now or have hospital decide that I shouldn't continue? I have no idea what you're talking about, in the sense that why would the hospital make your decisions for you? I mean, you know, I can only speak to Social Security disability. The hospital doesn't decide anything. You decide, you know. I can't do this work anymore. It's hurting me. I can get through. You know, whatever the case may be, I can financially stop working. Granted, it'll be tight, whatever. That's you. Having a hospital decide that I shouldn't continue, meaning they fire you for poor performance. By the way, if they do that, that's a good indicator that you can't do that job anymore. So keep those documents. If they give you performance improvement, what are they called, guys? PIPs. PIP, performance improvement. I can't remember, because that's labor, not mine. But I know my husband had to do some for some of his staff, so that's how I know the word. But it brings up a point, though, guys. If you get write-ups at work, which don't feel good when you get them, they're insulting. They kind of, you know, are a self-esteem basher, where they're telling you you're not cutting the mustard right now, so you've got 30 days to get it together, or whatever the case may be. It could be performance in terms of pace, keeping up. It could be attitude. It could be outbursts or treatment of other employees or things of that nature. Keep those, because if you're in a claim or going to have a claim and you're getting those, that can be good evidence potentially if they go towards one of your impairments, which could be an ability to keep pace. I can't move as fast. Or if it's a mental health thing where you are not able to control, say, anger management, irritation, and you're not able to interact appropriately with coworkers because you lash out. You don't respond in the expected manner in the workplace. So keep those things. Don't read them every night because they're going to not feel good, but keep them. And then when you get an attorney or a non-attorney rep, you might be able to use those in your case. Okay. It would be a third-party statement, but they're very helpful. It's not a medical statement, but it's an independent, somewhat objective statement by a third party who tends to be objective, which is the employer. Furry plants. Let me just touch on Angela first real fast, okay? Angela, she's asking about SGA and ARG. I don't think I said ARG. I'm not sure which acronym that would be, but SGA is substantial gainful activity. I have a playlist called that, substantial gainful activity. Angela, it will explain everything about SGA. And whether there's a certain amount of hours, that's kind of a loaded question. Does it make you look like you're not disabled? Does it make it look like you can do a little bit more hours and go full-time? Then it could affect. But is there a black and white number? Not necessarily, as long as it's not full-time or deemed to be full-time. Generally, there are other areas, however, when they're figuring out if you've done trial work period as a self-employed person. Self-employed people are held to slightly different standards because there is no pay stub from an employer showing what hours you worked. So I have to carve that out of this discussion. Hey, Furry. Nice to see you. Furry plants and coins. You know, what kind of plants are furry? Sometimes they have little hairs on them, right? Let's see. Jay Dilly, nice to see you again. Person working on my appeal told me that they are trying to get things in order the best they can, so I win my appeal. The doctor who will review their work will make the final decision. I think you're talking about your adjudicator, not your attorney. That's very sweet that they I hope they meant it when they said they're trying to make sure you prevail. It means they think you're disabled, and that's half the battle. So, yeah, the doctor will review their work, who will make the final decision. I will say, and we just had a video out on this, I think it's out or coming out, that there is going to be a 2-year situation where an adjudicator for physical cases that can be proven on physical alone, and this probably applies mostly to the older crowd, but not necessarily, they can make the decision without it going to the doctor for review of the records. Something to that effect. If I put the video out, I'm pretty sure I probably put out the written spiel about it as well, linking it. But that can help. We haven't seen the result of that yet, by the way, and it's been going on for like a month, but supposedly. In theory, then, the few weeks to a couple months, I suppose, of when the doctor is looking at it, the internal doctor who reviews everything, your CE, your treatment records, everything, to try to peg you with an RFC, and which then under the law says whether you're disabled or not, depending on your age. If it doesn't have to do that, that's one less step in the process, and that means a little bit faster. And it would generally be only for probably those that you can skip it probably if it's going to be an award, but if it's going to be a denial, they probably have to get the doctor look at it, and not make that decision themselves. So anyway, anything to help it be more efficient and faster is good and accurate. Okay. Jay Dilly's 64 years old. And you're saying you also applied the MedVoc rule, of course. Yeah, I mean, you're in a good age bracket there, Jay Dilly. I mean, you've got the least amount of things to prove relative to others, right? Hi, Mr. Vincent. Nice to see you. Israel class, my email. You can email, I'll make it as easy as possible. Instead of my name, contact@joydisability.com. Contact, CONTACT, contact@joydisability.com. Okay, let's face this. Hi, let's face this. Nice to see you. Let's face this has a question. Please explain retroactive versus back pay. Aunt filed SSDI in 2013, but never finished. Completed application April of 2024 at 62. Okay, so she never filed back in 13 then. She tried to. Looks like she never did. Flash forward, 11 years to 2024, and she files, and now she's 62 years old. The onset date is 1 of 2017, which confirms that it's not back to 13. Is she eligible for some type of payment from back then? If it's SSDI, let's face this, then from the time she got her protective filing date for the 2024 application, that might be April, that might be before April, because you say she completed the application 4/24, but if she entered their system, let's say online, and got a reentry number back in January of 2024, then January would be her protective filing date and become her date of application, which is good because that gives her more of those back benefits that otherwise would have been scrolling off, because they can pay retroactive benefits up to 12 months before you apply if you are found disabled and not in a waiting period. So if they agree that she was disabled January of 2017, if they find that the medical evidence from then supports that, but she didn't file until April of 2024, and let's just say that was the application date, They will pay her up to 12 months before April of 24. So that would be through approximately April of 2023. And assuming that's not in her waiting period. Since she was disabled back in 1 of 2017, they are finding out in our hypothetical here, then yes, that 5-month waiting period would be the 5 months preceding the 12 months up between 324 and 424. I'm sorry, 423 and 424. So you'd have that 12 months being her payable months. The 5 months before, right before then, would be her waiting period. No pay for that. And she got the 12 months, the maximum 12 months retroactive she could get. That anybody could get under that scenario. And so the back benefits will include those retroactive months before the date of application, plus every month that happened at 424 and after. Okay. So if she prevails, she could have quite a little nest egg of back benefits, but it's not going to go back to 17 because of that limit of 12 months before the date of application. So retroactive is everything before the date of application. It's just like a subset of what could be her back benefits. But back benefits will also include everything after that up until the month she's approved. That will all be in her back benefits. Okay? Hope that helps. Oh, Viv, thank you. My gosh, I have total brain fart. PIP, Performance Improvement Plan. What did I call it? I think I just said Performance Improvement, what? Yeah, plan. Get your plan together if you get one of those notices, right? And fix it. Yeah, keep those, guys. If you're having trouble succeeding on the job and they're giving you warnings or PIPs, I would keep that documentation. Emails, send them to you, print them out, whatever you got to do. Keep it. Hi, Matthew. Glad to see you're trekking along, Matthew, with your case. Hang in there, pal. Okay. Neolog. Nice to see you. Is tinnitus a condition that should be reported on a review? Yes. Yes. In a claim. In a review. If it's a new condition, you're going to report it too. If it happens in the interim, whenever you have a pending claim, you get a new condition, you report it right away to your adjudicator, and you treat for it. If you just claim it, then it's never going to be a found MDI, medically determinable impairment, because you have not received treatment, and MDIs can only come from your medical records. But yeah, tinnitus has functional limitations. I have so many people with tinnitus. It's very, very common, particularly as we age, it seems. Ringing of the ears. Sometimes there can be some dizziness with it, but then we're talking maybe Meniere's or something. But it can be interruptive of sleep. It can interrupt our concentration and our focus, which can then interrupt our ability to do high-skilled jobs. It can also impede our hearing, which can then be, it doesn't mean we're deaf, but it can be interruptive of hearing people, including on the phone. So it's really important. And you might have other symptoms that go along with it too. I don't know if it comes with pain of some sort. Earth sign. Can I send in my medical records with my function report? Or separately, but send them in. But when you send them in, I'd put a little note on top that says, this is not all of the records from this doctor necessarily. Please be sure to order. You're just giving them whatever you got so that, who knows, maybe it'll be enough to make a decision. But if not, please don't drop the ball, adjudicator. Please order the full official set. I'm just trying to help, facilitate this in case this would be enough. Oh, Mr. Vincent, you're very sweet. Okay. You got it. Let's face this. Okay. All right, guys. QD48. Okay. You hired a disability attorney. Good. Is that also good? You're from Jacksonville, Florida. I hope it's nice and warm down there now. I am biased. I think everyone, almost everybody, should have a representative that's experienced. It doesn't have to be an attorney if it's a good non-attorney rep. On the same token, if it's going to be an attorney, it needs to be a good attorney, one who's kind of laying it all out there, I think. I don't know that I really suggest one that tangentially does SSD because they tend not to be very good at it. They're not really up on it. They don't devote the time to learn the ins and outs as we go through the entire ever-changing landscape of Social Security disability and SSI. So whether it's an attorney or a non-attorney rep isn't so much the question as to what is their caliber of work. That to me is the biggest thing. And for a lot of people also, are they communicative? Are they going to be responsive if you ask them a question? Or are you going to sit there and not even know if they're alive? I can't talk more and more about the portals. We have a portal that we use. I think it's worth its weight in gold. I mean, I don't like the prices keep going up, and I usually send a little, what are you doing raising the prices? When I get it. But thus far, I'm still hanging in there. So it is really helpful because it is a communication portal, whether it's documents, messages, texts, comments on documents between me and my clients. So it's very valuable, and my staff in there too. So it's really good, I believe. So we're doing pretty good here, guys. Any more questions? I am not seeing any more questions. I don't know if anybody has any more. But Cutie, yeah, I think it's good that you did hire somebody, retain somebody. I mean, why do it yourself? I know some people want to do it themselves because they think they're going to save a buck. And technically that's true. If you prevail at the same time you would have, you probably would save a buck. But I don't know that statistically speaking, it's wise. Just saying. I mean, we've been involved in legal matters here for a few years now in the family estate type of regime due to some passing parents. And I used to do wills back in the day when I did state law a lifetime ago. And I hired somebody. In fact, we had 2 different lawyers in 2 different states because 2 different parents, one grandparent, one parent passed away. And it is so worth it to not have to, well, one of them was really good. The other one was a mistake. But it was definitely worth it for the one, worth doing. Just to try to navigate an area that I am no longer familiar with, and that's like anything else, you have to be on top of it, daily, weekly, if that's your legal field. So I can't imagine doing it without having hired a lawyer in that area. And I would say the same for this. I just do. I know you can do it without, and some people do win. I mean, there are some cases that are going to win, boom, like that. So that's unfortunate for them, but in terms of the impairment they have, it's that obviously bad. We're talking about compassionate allowances in particular. But yeah, I don't think you need to use a lawyer for those. But for everybody else, I just think it's a smart thing to do. Okay. And obviously I'm biased because it's how I make a living, representing people. Okay. So some more questions popped in. Tara Denise. Let's see. Is there really an advantage? Tara was here first thing. I appreciated that, Tara. Is there really an advantage to filing for a child age 23 under DAC? All mental health, bipolar, depression, anxiety, PTSD, mood disorder, ADHD, agoraphobia, and so lots of stuff going on. Never worked. IEP since elementary school. I get SSDI. Tara, are we talking about you? You're getting SSDI. See, the facts are not clear. If you're getting SSDI, is this your child, maybe, that you're talking about? You're getting SSDI, and therefore the DAC would be kicked in. I know we talked about this last week, right? Is it worth it to do? Yeah, because that child is going to be stuck with SSI forever. I think you want to consider DAC. If you have the proof to show that they were disabled before age 22, then they could be on Social Security and not DAC. Social Security comes with all sorts of benefits. I'm sorry, Social Security, not SSI. DAC has far less rules to follow. It's almost exactly like SSDI, except maybe like the marriage rule. And they can inherit. You can gift them. You could give your child $10,000 if you win the lottery, and they're not going to lose their DAC. They would lose their SSI, right? So, yeah, I think it's definitely advantageous. The DAC might be so low that they have DAC and they have SSI to bring it up to the 967-ish. And that's fine. They'll still have the SSI rules to keep the SSI component. But for now, that might not be bothering them, But later on, if the shoe fits and they can come into something more, they can do that with the DAC. And if they do find that they can start working part-time here and there, maybe their own little shindig of some sort, working very part-time, they don't have to pay $1 back for every $2 earned under SSI, paying back SSI, getting it offset. That won't happen to the DAC as long as they're staying under the earnings threshold, which is for sure probably going to happen. So there's a lot of benefits to the DAC over the child remaining on SSI if that child was disabled before age 22, in my opinion. Okay. I know it's a pain to file and prove it. I know it. And for young people, it's particularly hard, but it might be worth it. If you have, Mr. Vincent, good question. If you have multiple conditions, does it make your application process longer? Well, it depends what you're talking about. Application process. Application process is the process of getting your application in. Once it's in is when the workup happens at the SSA, right? So when they start doing their job of working through developing that case and determining if the person's disabled. So if you have multiple conditions, you're going to be, I'm getting in the nitty gritty here, but on the beginning of the application, you have to list your conditions. So yeah, you're going to be listing more than one, right? If you have more. So that takes you a few extra seconds, right? And then if you have different doctors, and you probably should, if you have multiple specialized conditions, you probably should have multiple specialists for those and not just your primary care. Those would, for every doctor you see, you're going to be putting them in a separate page in the online application. Same thing if you have a paper application, you're going to have a page for each office you go to. So in that sense, it takes longer to process the application. We did one the other day, me and my associate, and there was like, I shit you not, people, like 25 offices, providers. It was something that much. It was really heavy. And I'm like, so I was going over a few things with him in terms of confirming where our alleged onset's going to be and the strategy we're taking on that. And then I'm like, all right, well, this is going to take a long time, so you can start putting in the doctor's information, and then everything. I submit everything. So there's two phases to the application online. The first, when you're connecting yourself to your SSA, how they have you in there, so it's all going to be under you. And then it's some basic background stuff. And then when you then if you submit that, that's like not the longest section. That's when you haven't done any medical doctor information. That's the first part. And it's technically, I think, the application. Then once you hit submit, and it'll tell you, you can't change this once you go in, which you can't on there. Of course, you can always alert them. Hey, I did a typo. I made a mistake. I had a brain fart, whatever. You can always alert them separately. But once you submit that, you can't change it online. And then it bumps you right into part 2, which is all the medical questions and all the doctors. And I think if you don't get that section, this is the one thing I don't like that they do. If you want to take a few days to enter those massive amounts of doctors, if you have a lot, they're not going to let you, well, you can do it, but they will start shooting out letters saying, you got to finish this. You got to get it to disability section, which is the medical portion. It is the equivalent of the paper form called the SSA-3368, but it is automatically part of the online application, which is handy. So you don't have to do it on paper. And then you after that first section I was talking about, and then the second section, there is a review page. And I always think you should make a copy of that, however you do it in your system. I mean, I can say print to a PDF, and then I could save it as a PDF file. And that's before I submit it. That way, if something glitches and they lose it, the SSA technology just wouldn't be the first time. I have a copy of the answers, and then someone can go in and just put them in exactly as they were. Same is true with the second section. But after the second section, also, once you do submit it, and hopefully you kept a copy before you submitted it, it'll say, when you read that big long page after, I make a copy of that page too. It says, thank you for your disability application, because I want to have that proof too. If they say we didn't get your, I'm like, well, then you shot me out of, how'd you send me this response if you didn't? It says you took my disability application. But that, it'll say, do you want to print your receipt? Of course you do. Of course. And you want to save it to your device. If you have to take screenshots of that, do it. But, try to figure out how to save it to your device or print it out on paper if you have a printer. One way or the other, you want to keep a copy of that because you want to know exactly what you sent in. Because if later on you're like, did I tell him about my chiropractor? Can't remember. You just go and you look. Simple as that. And for when I take a case that comes in after they've already filed on their own, once I get access to that document, if they have it already, that's great. Now I've already started to populate all of our information with what they have on initial. And then I can look at it and be like, hey, you claim this impairment, but I don't see, you're not see, you say you have plantar fasciitis, but I don't see that you have a podiatrist. Go see one, So I can start giving the advice in terms of what they have to do to make their case as strong as possible. So keeping those receipts is good. And yes, more doctors, I think, which could result from more conditions, Mr. Vincent, can mean it's going to take a little longer to input. And of course, if you have more medical providers, the SSA, the DDS, will be requesting from all of them, and they might be a little slow. So you have more people that can be slow, so that could slow it up too, but it's more information that can help your case. So I generally think more is better. That's a general rule. Okay, Matthew brings up a good question. Now that I have a 10-pound weight restriction from the cardiovascular surgeon, will that help my disability application because I can't use the grid rules as I'm only 44? It will, Matthew. I think they take these kind of restrictions to heart, the adjudicators, because it is your very specialized doctor, cardiovascular surgeon. That's not your general practitioner. He's very much a specialist, and he's putting that weight restriction because of your condition. 10-pound weight means he's basically limiting you to what the SSA would define as sedentary work. So will that win you your case? Absolutely not. Physically, you could do sedentary work. So now you have to carve out other jobs in the sedentary range. How do you carve out other jobs? Well, maybe some are high skilled. Prove you don't have skills, or you have no transferable skills. Or you don't have the education experience. Maybe those jobs require a lot of finger dexterity and you don't have it. Don't know all the rest of your problems, but or it could be if it's mental health, you might be relegated to the unskilled type. But then you would be still have the burden of proving that you can't do unskilled sedentary work, and that's that youth thing we were talking about, Matthew. When you're under 50. And that's when, if the mental health can get up to the level where there are no jobs that can be done because of this particular factor, that's a 4-prong area of mental health. I know I have a video on it where if you have a substantial loss in the capacities to do any of the 4 areas, any one of them, you are not able to perform any job because they are required in every single job, skilled or unskilled, sedentary or heavy. So it gets a little complicated. There's so many different cross, that's where we say you got to weave that needle to catch them all. But that is a, in terms of weight restriction, that gets you down to the lowest really possible. If the judge had, if the doctor had said no more than 2 pounds, that would be even better. Because that means you can't do a full range of sedentary work. Taylor, does your CRD, I think you mean CDR diary date, change after 55 years old to every 7 years? I keep reading different answers on it. It's confusing. Yeah, I don't, if you linked any, I would take a look and see if I found that credible. I like to vet my sources and make sure they're authoritative or otherwise somewhat persuasive. But I would say no, that's not true. Because again, I think I spoke about this before. You could have won at 54 because you had a particular kind of surgery that takes 2 years to heal from. And you had high-skilled work. You have no mental impairments that would prevent you from the high-skilled work, but you just couldn't do the light nature of that job. But in 2 years, you would be able to do the light nature of that job because the recovery from that surgery would have kicked in. They might put you on a 3-year diary. Makes sense, right? I mean, totally makes sense. It sounds appropriate. So I'm going to say I don't think that that's true. It could be that there are many MDIs and disabling ones at that found you disabled that are not expected to improve. And that would mean probably that they were already at 5 to 7, potentially, or if you, or maybe they were, I'm trying to think here, with the age bracket change and the category change from 49 to 50 and then 54 to 55, that could affect things for some people, but I do not think it can be across the board because then that would be contrary to the rules. So I don't think it's across the board. I think it's probably, again, certain needle poking at certain impairments that would then be related to your age. So certain age / impairments. So I don't think it would happen to all, but I think it certainly could be true of some. Virginia Gomez, nice to see you. How long or more or less does it take for an appeals counsel to review a dire need letter for SSI? I would like to think they take a dire need letter and they read it when they get it. And then they, say, is this dire need? And then bump you to the front of the line. That makes sense to me. I don't know that it would be kind of ridiculous to let all mail come in. And, if someone's brief for their appeals counsel appeal comes in, they don't necessarily then decide your appeals counsel because they got your brief. Now they got to assign a team to it and blah, blah, blah. But a dire need letter, I would think, when they see the header that it's a dire need, I think it would be considered right away. And remember, you might want to attach proofs that you have dire need instead of just claiming it. Saying I'm broke, well, everyone going for SSI is broke. So I don't know that would be sufficient. If you're going to be evicted, yeah. If you have a new diagnosis of terminal illness, gosh forbid, that would be maybe a change of circumstances that's dire. Particularly if that was not on your appeals counsel, your original case. It wasn't like that. And then now, deterioration or a new diagnosis or something that's terminal. Eviction, losing your house, foreclosure, and you have documents that were, you have an eviction notice or that someone filed for foreclosure, the complaint you received. So attach whatever you can. Tara Denise. I'm applying for my daughter. She's 23. I received SSI. Okay, you're just clarifying. Yeah, well, as a generality, not knowing your situation, I say, why not? If you can handle it, because I know it's hard on people and it's hard on all claimants and any family members helping to go through the process because it's long and You might have to get additional evaluations, you know. And if she's not treating, obviously she has to be. Tara Denise. All right. She says, wow, if I win the lottery, like I really will. I get it. Does that affect SSDI? No, you can win the lottery. You can inherit. Someone can give you a nice, big, generous gift. It's all good. But that brings up an interesting news point I just saw out of Texas. There was suspicion about the lotto. Just putting it out there. I'm like, oh my God, it's so ripe for fraud and or abuses and money laundering. Not kidding. Just starting to hear about it. I think it was today or last night. So I think that the government of Texas is going to be looking heavy and deep into that. And if it's true in Texas, it's true other places too. But it's only just starting. The investigation is only just starting. And I don't know any of the details, like what made them suspicious. You know, I don't know. Insane, though. It really gives good credence to the thing they used to say that lottery is a taxation on the poor. I didn't really agree with it because it was free choice to play the lottery, and you know your odds are bad, and poor people aren't more dumb than the rest of us. So I was like, it's not a tax on the poor just because they choose, you know, they choose to play it, and everybody else chooses to play it, and you have to buy it. I mean, we could say potato chips are a tax on the poor, right? But if there's no chance of winning that big thing, and that was all a lie, whoa, because of fraud, this is probably going to be a big story. But anyway, okay. Earth sign. What is the 14 days for processing name? It's been over 14 days since my doctor submitted the medical certifications. I don't know what medical certifications you're talking about. Are you talking about he sent in medical records, or his office did? And who said 14 days for processing? Don't know what you're talking about, Earth sign, because we don't speak in that language from this side of it. So let me know more specifics if you can. Okay, Matthew, great point. If you guys are doing a paper SSA 3368, that means you've applied and you're putting your medical information. It's the disability report / adult SSA 3368. It's for people that are not applying online. They say if you have more than like the 5 or 6 spaces they have for medical providers, go ahead and use section 11, which I'm guessing is remarks. Is that remarks, Matthew? And stick it all in there. Yeah, if you have one more, you could do that. I mean, but he says, could I just print off more pages of the section 8? Yeah, I would do the same pages and add them on. That way, you know, you're not missing any of the questions that they ask about them. And I say that because every time I see someone put stuff in the remarks for a new provider, they always miss some of the questions. It could be the phone number. It could be the start and last date. So yeah, I'd say go ahead and do the pages. Either one will work. It's going to get your application is your notice. You can always send in more providers if you forgot any or new ones come about after to the adjudicator. Make sure they get them. But yeah, you kind of want to go out of the gate with your strongest application material, with everything being as perfect as it can be. Not perfect in the sense of prettiness, perfect in the sense of complete and responsive and not damaging inadvertently. Yeah, I get what you're trying to say, Matthew. Yes, add pages, and you don't even have to change the 8A7, 888. Just attach them. It doesn't really matter. They're going to, if you want it to look pretty, go ahead and do that. But it's going to be attached. So is this Scopo 80 with the $sign? I had my hearing with the ALJ judge and is requesting a medical report from physical therapy, which I still attend. Is that good for my judgment? Can't say. He's being thorough. He has to be thorough. Whether he's, sorry guys, getting a little sore sitting here. Whether he's awarding you or denying you. But I will say, I love physical therapy records. There's never been There's never been a physical therapy record set that I haven't loved, because it gives details of how the person's doing. It often, these therapists are, I think, you can get 18 sessions of physical therapy in a very short period of time. What might take you 7 years to get from your specialist because you don't see him 18 times in 2 months. You follow? So yeah, I think it's good. And they often ask you, they look to see if you're in pain while you're doing your stuff, and they record it. If they usually often ask how you did after your last session, were there any ramifications, soreness, anything like that, pain. They want to know if you're moving better than you were since your last session, or since you started. So if you're not, it's an opportunity to say, not really, not yet, hopefully and soon. And so it's objective evidence from someone who has no reason to say something inaccurate. So physical therapy records, I love. Matthew McGraw. No, I don't think a breathing test is the same as a sleep study test, but just put it in other. You can write other and put it in there. Taylor. How you doing, Taylor? If you work under the trial work period amount of 1160 gross amount, do you need to inform the SSA? I believe so. Also, if you work under the amount and stop working, does that trigger a CDR? So the first question, I believe you should report any work to the Social Security Administration. I think that's our duty, and I think that's even in some of the narrative you received. So they're going to want to, because who makes the decision if it's trial work period? They're going to want to make the decision. I mean, some people think trial work period is SGA, and they could be saying, I'm under trial work period, and they don't even know what it is. So you just want to report it, in my opinion. They might say, great, let us know in a year if it changed. I mean, that's fine, but you did what you have to do. Also, if you work under the amount, so under trial work period amount, TWP, and stop working, does that trigger a CDR? No, do not believe so. Popping out of TWP and working SGA could trigger a CDR. But you say working under TWP and stopping working. No. I have no reason to believe that triggers a CDR. Okay. I must have jumped around. Sorry, guys. Oh, Mr. Vincent asks, how long does a typical, you got such great questions, Mr. Vincent. How long does a typical ALJ hearing last? And do they usually try to rush you to get to other cases? Thank you. Well, this is a loaded question. I hope I don't get myself in trouble with my ALJ. It depends. My ALJ hearings tend to go long. I think they want you in and out in a half hour. I think a lot of them schedule every 45 minutes. So if you're out in a half hour, they got 15 minutes to the next guy. However, rarely does one go under an hour for me, because I'm a lawyer who cross-examines the VE every single time. Unless that judge has indicated to me that he's awarding, and if he's asked the VE questions, I'm cross-examining. I'm going to make sure, unless the VE gave all the answers I wanted, every single question, then I'm not going to upset a beautiful cart. Why would I ask a question to upset what is just perfectly laid before me? So when a judge makes it clear that he's going to award, or if he says, I don't need to hear anymore, because usually they give you quite latitude, even though they're on a schedule. I mean, if you go really long, they can get a little aggravated. But So that might be, I mean, it's not a for sure thing, but that can be indicative. So, I mean, I don't know if I've ever said this, but if a judge ever says that, I think I have enough, counselor. Like, stop your questions. Like, whether I'm direct examining my own client to bring out more information that my client and I know about in terms of his functioning that the judge didn't ask, or the VE, you know, maybe I would come back with something because it's on the record, like, okay, judge, well, if that means you're awarding him fully favorably, I rest my case. You know what I mean? Like, so, but if not, judge, there's some more important items to get on the record, you know, and then the judge, you know, but, you know, they're usually, I find them to be, you know, just trying to do the right thing, move things along, but they're not looking to deprive a claimant of their due process rights to get their hearing out the way they want it. I don't know how far that acquiescence will go. If a claimant wants to talk for 3 hours, let's say it's an unrepresented claimant, I think they're going to shuffle him along. You know, he can't just, they're not going to let him talk for 3 hours. But I would say 30 minutes to an hour is typical. And I won't say they try to rush you to go to other cases, but if they feel they've heard enough, you know, they might kind of indicate that. And it really depends, because there's always an attorney on all of my cases. You know, if someone is a pro se person, it's just them and the judge. I can't really speak to that because I'm not there. So anyway, they do have a schedule though. And you know, a lot of times I'll say to my clients when we get together after we've been together all prior to this and done a hearing prep and everything, I always say, I'm going to call you a half hour before the hearing. We're going to make sure we're both connected through that link for the hearing that you got in the email and that I got in the email, and make sure we're both in front of in the waiting room of the OHO. And it says, we will let people know you're here, and they'll let you in, you know, when the meeting's about to start. That's what we want. We want to be able to see our own face, make sure our little microphone is on, and then we sit out and wait. And sometimes the hearing will go off very late. It won't go off on the right time. And I've already prepared my client, like, you know, I give them a half hour. If they're going to be late, it's because of the prior hearing. Usually it's because the prior hearing went over time because they went longer. And I can't really begrudge anyone that, because mine always go over. You know, like I'm not cutting myself or my client off at 30 minutes if there's more that needs to be said. You know, questions that I'm divulging from him that are relevant to and correspond to the evidence in the file. So they do start late, and then we're always ready before the hearing starts. Also, for the reason that sometimes, and this is not that uncommon, I'll get a call from the judge's assistant or clerk. I don't know what the title would be. And she says, hey, Judge Jones's 10 o'clock didn't show up. Do you guys want to go early? And I've already prepared my client for that too. And I said, we got everything straight. So you don't have to worry more and more and more. And we sit here and wait, you know, 45 minutes. We could start, if they do that, you know, we'll say, yes, does that sound good to you? And of course it does, because they're on the edge of their seat. They didn't sleep the night before, and they want this over. Win, lose, or draw, they want it over. So we'll, you know, and that's a nice thing to do for a judge, to be ready, and to other claimants to be ready and prepared early and to go early, rather than wait for the exact time you were supposed to start, because they're waiting too. And if they can get back on track with their schedule and we can help them do that, why not? I think it's a good thing to do. And why not keep your judge happy by being courteous like that, right? Get more bees with honey. Okay. You're welcome, Virginia. Where am I? This is from, oh, is this still Angela or is this someone different? Does a winning lawsuit affect my application or anything else? It depends what your application is for. If it's for SSD, generally not. But, you know, there can be a little tricky, little weird thing, guys. What if you have a lawsuit for, I was fired because of my disabilities when I was totally capable of doing the job? That would be like a discrimination case that some people file, let's think about it for a second. I'm suing my employer because he fired me saying I was unable to do my job, and I'm in a wheelchair or whatever the case may be. And he says, but I was fully capable and did my job perfectly. So they're just discriminating against me because, they don't like me because I'm disabled, even though I was doing my job with accommodation or without. Okay. And sometimes I hear them want to put that in front of the judge. I'm like, why would you put that in front of the judge? You're basically saying you were able to do your job. Case closed. You just lost if you're able to do your job. And you were fired not because you were not able to perform it due to your disabilities, because that's a valid reason to terminate somebody if they can't perform their job with those accommodations, with or without accommodation. So why would you want to tell the judge or the SSA, I believe I can do my old job. I did it great. And I got fired because I do happen to have a bad back. I'm filing for disability, but I could do my old work. You just lost at step 4, right? So you got to think of lawsuits like that. But if it's something like I was in a car accident and I'm waiting on a settlement, is it going to affect my SSD case? No. If you have SSI, obviously coming into money can have ramifications. So if you have a lawsuit that could bring you money and you have an SSI claim, you might want to make sure that your other lawyer, the non-SSI lawyer, is aware, and tell him that you need to discuss a special needs trust or some other kind of method to protect your SSI from being canceled due to that huge resource you're about to come into, whatever that settlement is. Remember, the resource limit is only $2,000 for a single person, so it's ridiculously low. Anyway, things to think about. Hey, St. Louis, good to see you. What do we have here? Hello, what does a good attorney-client hearing prep session include? What are best practices for attorney and what are best practices for clients for the prep session? Well, obviously, every attorney is going to differ, and non-attorney rep, let's not forget them, because there are some very, very good ones out there. Very, very dedicated. The way we do it here, now keep in mind, it is never the case where the client's never interacted for me for the whole time since we started. So it's never one of those things like, well, I never heard from my attorney and now we're finally having a hearing prep. It just doesn't happen like that. However, and I don't like to do hearing preps weeks in advance because people forget what you said. It's, you know what I mean? At the time of hearing, it's like kind of out the window. I like to do mine like 1 to 3 days beforehand. Sometimes it's a Sunday we're doing it. I mean, if I want to do something else on a Sunday, I'll try to do it on the Saturday instead, or the Friday. But to me, what we generally want to do is discuss some of the rules, like you have to be alone in a room, and you're going to have to swear under oath or attest to the fact that you're not recording it. All those new things with video hearings now. And that the 2 broad areas that will likely come up, which could be your prior work, if they need more details on that, because that's the one prong. And the other one is your impairment-related functional limitations in your day-to-day. I always say, as a general rule, it's kind of like what's in your function report. And that is the 2 broad areas before they're going to hit on the vocational expert. So then we go into what the vocational expert does, how there will be hypotheticals, and the judge isn't really talking about you at that moment because we don't know what hypothetical he's going to attribute to you. And then also the fact that you're probably not going to have the result of your hearing at the hearing, and you probably have to wait. So that's like, in the most simple of cases, that's kind of what we go over. Now, when we go over the second part, which is all about those functional limitations in your day-to-day, like your activities of daily living, that's what takes up the most. Number 1, we've already done the work history. If they did the work history when they were on their own before I got involved, it's very possible prior to hearing that I will have done a new one with them with the new questions on the work history report, or if I think theirs was not clear and could be damaging. That's when prior work is really relevant to them, particularly a grid person. So I sometimes submit an amended, entirely new work history report, so that when we're at hearing and I say, Judge, do you need anything more on, if he says, counsel, you do all the question asking, I might say, Judge, you need any more on work history? Judge, so-and-so exhibit is a updated, corrected function report with all the newer work history questions, because I think it's relevant here, Judge. And I think when the claimant drafted his own work history, he didn't really understand that all the questions were important and what they meant, and he left a lot of things out that would be relevant. So there's that. With the ADLs and all those questions, that's when we go through and I try to hit on some questions that I might not know the answers to because we never touched on it, like the one about have you been on vacation in the last 2 years? I always ask that one because sometimes the judge is going to pull that out. And if that person has gone away on vacation, he wants to be prepared to answer that and answer it accurately, but in a way that is going to shed light on how different that vacation was, how limited he was, that kind of thing. Sometimes they'll ask it in a way that's, have you been out of state in the last 2 years? That kind of thing. So going through questions, if you're ever thinking about what questions should be asked and prepared for, I say think about the function report. Think about those questions. Judges often ask those questions about your shopping habits, driving habits, and if you're not sure what is a important thing to share in a function report, which would then also mean testimony, I consider, think about looking at the playlist for function report, because it kind of gives you some red flags to think about. So, and I have from the ADL stuff, I have a whole page of all those questions that I asked. And then as I'm at hearing, the judge usually asks a bunch of questions. If one of my questions on here has been asked and answered, now I can put a line, check it off that's been asked. I don't have to ask him now when I do my own direct examination. And then if my client gave a weak answer that didn't really focus on the things that I know about that answer, that it blipped out of his head, because that still happens even though we prepped, I'll bring it up and I'll be like, when you were saying that you, and I'm trying to think of an example that you can, when the judge asked you if you could drive and you said you could, did that mean that you can drive unlimited, or do you have limitations to driving? And then I'm reminding him to say more. That question that he answered, yes, he drives. There's a lot more parameters that he needs to get out to make that a non-damaging answer, such as it's only local. My spouse drives me everywhere else. If it's going to be more than, say, a half hour, judge, because, or 15 minutes, because I can't wiggle around like I could do in the passenger seat to kind of alleviate some of the pain. So some of my further doctors, I always have to have a ride. And then everything else is limited to local. And even then, judge, it's only on the days that I am not, overly in pain from, whatever reason. So I don't drive even locally like I used to, but I still can drive and sometimes do if my pain levels are allowing me to, and if I have to, if there's a reason for me to do it. That's particularly important for someone who has pain when they sit. That should affect, if you think about it, that would affect driving. You'd probably be limiting your driving to short things, which usually means local. So those things are how we, so my notes let me know if the judge asked that question and I see it as a unhelpful to my client answer, I want to go back in there and get more out of my client in front of the judge. So he has a testimony that clarifies that answer. It wasn't quite the way it left a lot open. It just said, yeah, I drive. Well, then go be Andrea, whatever his name is, the race car driver. You know what I mean? Like, oh, you could be a taxi driver. You could be a delivery guy if you can drive. No, not really, because I can only do this. So remember, you're always trying to put out the limitations, how something is not normal like it was when you were not impaired. And that's what we're trying to get out. And if you follow any of those like new court rulings, and we have a playlist on that, there's not that many in there yet, maybe 10, if that. But 2 are coming out very soon. there is an emphasis on the testimony, which could also be what you said in your function report. So it could be the current testimony that you're hearing and other statements from the claimant. You really want those to be tied into medical evidence. So like, you know, if you're talking about a bad back and difficulty sitting from the bad back, you know, bad back's in the medical records. So what are the ramifications from that? You want to bring out all those limitations and functional activities, you know, the tasks they do around the house and all that because otherwise the diagnostic on that doesn't really mean anything because there's no evidence of how it limits the person. But his testimony is what ties that in. So, and it does, of course, help if the claimant's patient's complaints were reiterated over the years by the doctor. But they're usually not that detailed. So that's why this other kind of explanatory statements in the function report, in testimony, and whatever we can glean from medical records can help put the gravy on the impairments. You know, it drives it home. And there was a court case that expressed how that was very important because the claimant's never complaining about it. You can have any impairment in the world. It could be severe, but if it doesn't stop you from doing anything, then it's not really a big deal. That's when it's a non-listing, right? That's when all these things count, how it affects your day-to-day. So that is what I think we do for hearing prep. And so far it works out like a charm. Doing that for probably the same way for a very long time because there's probably been questions that have been added to my normal repertoire as things became more common in the field and at ALJ hearings, you know, because everything morphs over time. So you have to be current. What are ALJs kind of asking now? What are they finding important? It could be as simple as, here's a funny one, texting. Some judges had been known to, if a person texts, they would find that his fingers are not that impaired and all that. And so now one of our questions is that finger texting or dictation texting? Because if a judge says you text and my client says yes, he might also say, I do it by dictation, judge, because now they have the, you know, voice to text. Excellent answer. And he probably remembered to do it because we talked about it. And he said, yeah, I did. You know, when I said you fingered or you did it, yeah, I used the dictation. Perfect. When he asked about texting, you want to make sure it's clear. That's the kind of texting you're doing. You're not doing beep, 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 beep. And my kids laugh at me how I text because I text like this. Like if I'm using my phone, and I don't do this very often, my texts with my clients are actually through my computer to their phones. It's beautiful. It's through that portal I was talking about. But I do like this. And they laugh at me because they're like, da, 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 da. I'm like, you're going to have thumb arthritis when you're older. Mark my words, kids. They just laugh at me. The old cute mom that I am, right? Neolog. Is it a good idea to mail a review back registered mail? What kind of review? You mean a report? If you're mailing it, heck yeah. UPS, FedEx, you want proof it got there. And you want to keep a copy in case it didn't, so you can resend it. Not a bad idea to fax it. I don't think claimants can upload. I could be wrong. Like we can. Their representatives. But anything you send that's important, deadline, whatever, needs to get in there. You definitely want to make sure you can prove that it got there. So you can rest easy when you get that tracking back. Yeah, registered return mail. I know what you're saying. You're talking about U.S. Postal Service, which is the weakest of the ways to mail them, but we still use certified mail. Return receipt requested with the green card costs a couple bucks extra, but it gives you can still get the tracking online, but it's nice to have that signature, you know, a live body from the DDS or the SSA confirm that they got it. But I like them to get it fast too, so I like to fax if there's no upload. I just faxed a function report in for a new client. I'm not connected to his case yet because the SSA is very slow. I don't even like doing all this work before I'm connected, but I can't let the guy hang either. So I did that last night, I think, and I faxed it, and I have the fax confirmed. Earth sign. Can I win my case with SSDI for plantar fasciitis? That would really depend on your vocational profile and all that other business we always talk about. But does it stop you from sedentary work? Some other cases, if you can do sedentary work, it wouldn't suffice. So you have to. I don't know that I've ever seen a person win with just plantar fasciitis, to be honest with you. Usually there's something else going on. I mean, if you're over 50, or, we all start falling apart. So you got to use all those things. If you're under 50 and all you have is plantar fasciitis, considering that it's probably curable if you see a podiatrist with certain therapies, I don't know that would be strong in and of itself. It would be limiting, but maybe not. Remember, you got to wipe out all 12,000 jobs. Tara's got a little addition. Hi, Tara, again. I guess I should have said, will passive unearned income, not from a job, affect my SSDI? If someone were to gift me some of their lotto winnings or give me no, you can be gifted hugely. Yes, SSDI. Remember, SSDI, Social Security Disability Insurance, is your Social Security insurance that you paid for, right? It's not welfare. It's not a charitable gift from the taxpayers. It's not SSI. It is insurance that you bought. And so as long as you remain disabled under the rules, you can be gifted for sure. Okay. And you shouldn't have to report it either. Now, if they send you a 1099 saying you earned it, that's another story. That's a problem. George, I'm not going to be able to answer this. If you have severe infection staph ×3 and take 4 antibiotics per day for life, does it stop you from working? Remember, everything comes down to your functional limitations, no matter what. Short of meeting a listing, can you work or can you not? Do the symptoms and the limitations from that chronic staph infection, I guess, and or the antibiotics, does that prevent the ability to do all 12,000 jobs? And if so, why? How? You got to prove it. So I don't know if that would do it. Maybe if it eliminates, if the impairments or the limitations from that carve out. I always say there's that big bowl of 12,000 jobs, and we need to carve out every single one of them. It's fun. I don't have the form in front of me, Matthew, so I can't respond. I don't pay attention to the numbers, by and large. Da-da-da. Okay. Balut projects. How hard is it? We've talked about this. There's videos on this, Balut. How hard is it to get SSDI application approved for a veteran who has 100% disability, permanent and total? Incidentally, if you're the veteran, thank you so much for your service. It's like my mantra group of people. Aside from that, it's no less hard almost than anybody else with the same vocational profile. Because remember, your 100% disability PNT does not necessarily mean you can't do one of the 12,000 jobs. Often that is the case, but the definition itself is not the same. The definition for the 100% disability PNT is not the same as Social Security's definition of disability, nor is it the same for LTD policies and all the other definitions of disability out there that can give people benefits. So I would say if someone is 100% disability PNT, they've got severe impairments. I know that from that. So we've met that hurdle, but that is not the final word under SS, right? So we use all those veterans records that we can get from the VA, all the medical records, the evaluations, the ratings as well. SSA does not have to find you disabled under their rules based on that, but they have to consider, and we just had a recent new court ruling on this, they have to certainly use all the medical records from there, just like all the other medical records you might have from outside of there. So these are potentially my favorite cases. Yes, St. Louis. The Supreme Court has ruled in recent months that a person can both be eligible or win both. Of course. You can be discriminated against and be disabled and not be able to perform any jobs. So if you're confusing what I said before with this, then you misunderstood. You have to, the facts will tell. You see? It's kind of like, not the same, but the fact that it can be okay and other times it won't be. Can you be collecting unemployment insurance while claiming you're disabled? Answer, if you have an answer. The answer is yes. You can validly be filing for both. You can validly have collected both, and you're not being disingenuous on either. You just have to know what the definitions are, okay? And so what I was saying before St. Louis, in case it was unclear, I said St. Louis, but it's S. Louis, right? I keep calling you St. Louis. I always do that. If one is saying in their discrimination claim that, and they're saying it now, I am able to do that job. They have fired me or discriminated against me when I was able to do that job. And I'm able to do that job, and they should give me my job back. That verbiage is testimony that can be used, and a judge is going to see that you just said last month that you are able to do that job. Do you see what I'm saying? It's what the evidence brings into both of those contentions. So, but on the same token, it could be a discrimination claim because 5 years ago, they discriminated against you in some way, shape, or form when you were able to do the job with an accommodation, and they treated you differently. And since then, of course, you've deteriorated, and now you have that discrimination claim is still going on, but now you're disabled and you can't work. You see, the devil's in the details and the facts, and that's why everything has to be fleshed out very specifically, factually, with all this stuff. That's why everything up here is general in nature, because there's always going to be variables. Okay, Matthew is asking about a certain question that they ask you in your application materials. When they ask you if you've had any type of training, specialized job, trade, vocational training, that kind of thing. In his particular instance, he did painting and drywall many, many years ago, but was never formally trained. That would be a no. I don't think that, like, they're more alluding to certifications, that kind of stuff, official training for something where you actually walk away with something. It's not necessarily, I mean, every job, it comes with training. So then everybody would have to say, yes, at my last job, I was trained how to wash dishes in that restaurant using their dishwasher. That's not what they're asking for. It would be like if you got CNA training, if you got an HVAC certification, paralegal certificate, that kind of thing. Master mechanic, a certain software training for programming, that kind of thing. So I don't think you have to put that down at all. Matthew. And Matthew, when they ask for training, I don't think they limit it to 2 years. So don't throw a limitation in there that they don't put in the question. If they say ever, then you go ahead and put ever. If you had CNA training and you had a certificate, Informal training doesn't count. Sorry, Matthew, I'm going to blow through these to see if there's any other questions, although I don't think there are. Oh, Mr. Vincent. Mr. Vincent. You have all the best questions, Mr. Vincent. Does the VE work for SSA or an independent? I believe they are independent, and I even say that. They even announced that at the hearing for every claimant. The SSA may pay you, but you are independent because they're going to get paid for showing up. So, yeah, they are independent contractors, but they are getting paid by the SSA. So some people say, but so how independent really is that? I don't know. I don't have a problem with 90% of the VEs. I just don't. I don't know. I guess it's because we have really good results. I don't know. Viv. Okay. Oops. Sorry. If I get awarded SSDI and they agree with my disability date in 2021, would I still have the 5-month waiting period before the benefit begins? If I get awarded SSDI and they agree with my disability date in 2021, there's always a 5-month waiting period, except for some few more rare disorders that are not part of this question. Yes. So if they say you were disabled back in 2021, depends when you applied. Remember, it can only go back 12 months before the date of application, right? For benefits to begin. So if they say you're back in 2021, you applied in January 2024, you can get paid back to January of 2023. The 5 months will have been before that 12-month period that you can get paid. They would assign it to some previous months. So it doesn't bump, it doesn't take away from your retro period. I don't know if that answers your question. The 5-month waiting period is in there. It's just not going to affect you because you can only go back 12 months anyway, and they're going to give you the 12 months. Yeah, S. Lewis, it sure does. For sure. Fox. Hi, Fox. Can you accept a small family inheritance while waiting for SSI hearing? You can do anything you want. If you have the resources from the inheritance and you haven't spent it down, then, they're going to look at that as to a resource that might put you over the 2,000 if you're single, 3,000 if you're married, resource limitation. So you can collect it, but rather than if you let it sit in the bank and don't spend it, and you kind of want to have proof where you spent it in case they don't believe you and think you put it under your mattress, you might, consider what you're going to do with it that might be smart, that would be non-countable. That could be if you need a car, one car is uncountable. If you have a mortgage, you might want to put it, pay it down. If you need a new roof, that kind of thing. So things you really need to look into and speak with someone about before you get that inheritance. Because once you get it, then you got to spend it. Or else for every month you get it, you wouldn't be eligible for SSI. But on the same token, if you get a decent inheritance, you want to use it for good. You don't want to just, I don't want to say the word I was going to use, toss it out the window. Where are we at? Oh, Baloo, you're welcome. You guys rock. I appreciate it. I appreciate you. Okay, Virginia, who asks to appeal the case, the lawyer or the clients? You mean who files the appeal? Well, every lawyer does things differently. We do all that here because I do not want anyone else doing it. I want to draft it the way I think it's best, blah, blah, blah. But remember, there was a question above, Lulu, who doesn't want to appeal. She wants to drop it, and she's suggesting her lawyer is saying, no, you can't drop it, which I disagree with, if that's what is accurate. If I'm understanding those facts correctly. I I personally don't know the lawyers that don't file the appeals themselves. There could be some. That's all I'm saying. Yeah, it's weird to me because those answers are important, very important, actually. So I think usually it's the lawyer. I think most professional lawyers. I mean, probably all. But anyway, I mean, the lawyer has to get the information from you, right? I mean, who have you been treating with since you applied? We get that in a data packet when we have to file an appeal, notwithstanding the fact that they are told to keep us informed all the way along, because we want to see it twice. Not to mention, different people work in different things, and we like a double set of eyes, and we want to hear it double from the client sometimes because they might forget something. So here's a second chance to make sure they didn't forget something, you know. Kevin, yes, and that's appropriate. I mean, that's their job, so that's good. His lawyer says that he will appeal if he's denied. Excellent. All right, guys, guess what? We're after the 2-hour mark. I went a little over. It's 3:16 Eastern Standard Time. All right, there's one more question. I'm going to get to it. This is it. VG Warren. Are we new? Do I dare ask? Because I hope I didn't forget a name. How often do people get approved for SSDI after being denied during the original and appeal? How often do people get approved after being denied during the original and appeal? Okay, so it sounds like you're asking how many people win on recon, I think. I haven't looked at a current waterfall chart, but the last one I saw, which is not that old, a couple years ago, it was 33, no, I think it said 38% in the whole scheme of all applicants prevails on initial, which was better than I thought. And I bet you that's mostly the over 50 crowd, by the way. They probably win way, way high. And then you got your younger people that are way down here at like 10%. And that's just speculation on my part. Recon, I believe it said 15%. So you got your 38%, add another, and then 15%. I think they mean 15% of the total that applied. So 15% can swing it on recon. I will say I'm pretty sure we do better than 15% here. But remember, we're doing work on initial and recon. We're not just letting it organically flow through the SSA process. We kind of get involved. So that it kind of boosts our percentages. Not that I follow the percentages because we're not allowed to share, apparently. I think that's a bar thing. But 15% seems very low, Oh, Virginia, thank you. I know sometimes I'm a little quick speaking, so it can be a little, I talk fast. Okay. Angie, good to see you. All right, I'm going to take Angie, even though we're going to close up after that, guys. Angie, good to see you. I applied for DIB in 2023 and for a job March of 24. Okay. Tried it, failed by 6/24. Okay, you only made it 3 months. That would be arguably a failed work attempt. Made about 15K. Good for you. Hopefully that sustains you a little bit. Also in 2024, I did some self-employment due to financial need, 1099. Was 15K. But after EXP, made 5K. What is the EXP, Angie? Can you pop that in? One more, please. Okay. Well, this caused denial. All right, we might have a problem here. Angie, if you want to, I might not be able to answer you here, but if you tell me a little more of those details, was there a gap between the self-employment and the 6/24 when you quit the W-2 job? Was there a gap? And if so, for how long? One more. Yeah, for you, Angie, of course. It's due to financial need and after EXP. What is that, Angie? Can you pop that in? Are you there? Well, this calls a denial. It could. And it wouldn't be they have to find that each one was a failed work attempt. So if there was not at least a month in between the end of the W-2 and the start of the SE, that's going to be one big successful work attempt if that lasted 6 months. So, but if it's broken up by a couple months in between, now we have a gap. And you retried to work again. It was like a failed work attempt 1, failed work attempt 2. And we could try to argue it that way. You're going to be over TWP, so no matter what, you're going to be probably, if you were to prevail, your TWP is going to be eaten up. So then you have to always be under SGA, or you will A, owe back every month you're not, and B, if it pops out of your EPE period, extended period of eligibility, this is after you've won, you will be terminated, and then you have to reapply. All right, I don't see any of those details, but hopefully that touched base on it could be a problem, but may not. It really depends on where your dates fall and stuff like that, and what you're doing. I mean, if they look at it and say, you know, Angie has a bad back, but she decided to be a contractor for a farmer, and I always use the farmer one, and was a hail baler and throwing bales of hay up into the attic all the time. Well, we don't think her back is as bad as she says because she was able to do that. So, you know, there's substance reasons and there's technical black and white reasons, like the money amounts. So got to look at all of them. Okay. All right, guys. It has been great. Guys, it goes so fast for me when I do this. I do lose my voice, though, I think, because I forget to do this. My big old Ozark. But anyway, good to see you guys. Expenses. Oh, yeah. So you made a lot with the self-employment. I hope what I said explained it, Angie. That those gaps and because it was self-employment, they're gonna be scrutinizing that to make sure it really stopped and started when you said. Your calendar helps. When you got paid helps. It was 1099, so that could help. There could be documentation there. It's really very fact specific. So, you know, sometimes they could find that you're disabled afterwards. It'll just be a different onset date, but these are things that you definitely have to address. And they should have sent you an 820 and an 821. Did you get those? Anyway, that's the opportunity to really lay it out clearly. All right, Christina, you're welcome. And I will talk to you guys later, okay? We'll be here next Wednesday, 1:00 p.m. Eastern Standard Time. And, of course, our regular video shares, 9 a.m., unless someone clicks the wrong button. I think one came out a couple weeks ago at like midnight. Yeah, some glitch there. I'm sure it was on our side. But anyway, it's been great, and I will talk to you guys later. Have a wonderful day and a great rest of your week. And if you need someone to review your current claim or you're thinking about claiming, you can definitely, if you go to joydisability.com, upper left is a link for a free evaluation of your circumstances. It's a very short form that you'd fill out right online, and it'll come right to the inbox. And we will let you know if it goes late and you don't hear from us in a day or two. Email me, stephaniejoy@joydisability.com, or contact@joydisability.com. One of us will see it. But we'll definitely take a look, see, and maybe we can work together. Okay. All right, guys. I will talk to you later. Thanks again.